Hello, welcome everybody. It's good to see, quite a packed room. Doors closing in a few seconds. One last participant. Glad you made it. Welcome. Hello everybody, welcome again to our panel titled Unlocking the Data Economy. Subtitled The EU Data Act in Practice, State of Play, Regulatory Interplay, and Future Ambitions. I've been told that we are the only panel today, not only today, during the whole conference, purely focused on the Data Act. So we're doing something special here. The Data Act. Before I'll introduce the speakers, I'll introduce myself. That's a polite thing to do. My name is Joost Gerritsen. Maybe you know me as the CEO of DG Beetle, but I also have an academic hat on as an affiliate researcher of the Utrecht University. I will be moderating this panel. And before I introduce these honorable panel members, I will give you a brief introduction about this law, the Data Act. Data Act is a European invention. It's a law already in force from September 2025, so it's quite recent. Part of the European data strategy, and the goal of that strategy, and of course that's also the goal of the law, is to create a so-called internal European data market. This market where data can roam freely from place A to B. So data transfers without barriers, and data can be personal data, can be non-personal data, can be all kinds of information. And the Data Act has multiple chapters. I think one of the most interesting chapters are about data sharing in relation to connected products and related services. And there are also a chapter about cloud services. Among other things, because the Data Act has more chapters than these two. And the idea is that the user, so everybody here in the room, gets control over his or her data in relation to connected products. So what are connected products? That can be anything connected to the internet. This is my paraphrasation. Think of a smart thermostat, and if we had one, I hope we could dial it down a little bit cooler, but okay. Smart coffee machine, smart vacuum cleaner, connected cars, even airplanes. So everything that is tangible, you can pick up with your hands and is connected with the internet. That are the data. Those are the data we are talking about. The data of those products. The Digital Omnibus, of course, also plays a role. I said that the Data Act is in force since September 2025, and already there are voices and ideas to change the Data Act, to make it a more bigger law than it already is. We'll touch upon that in a few minutes. So that's the Data Act, and we have 4 terrific speakers here on this panel, and they will bring their own perspective on this act. I'll give you a short introduction, and then the idea is that after the introduction of the speakers, every speaker has exactly 7 minutes to give a so-called lightning talk. In that talk, it must be clear from the get-go what is the conclusion of that speaker, and that speaker has 7 minutes to elaborate his or her arguments to substantiate that conclusion. After those 7 times 4 minutes, so 28 minutes in total, you, the audience, will be able to ask them questions. First, we have the Honorable Laura Drexler on the left. Laura is assistant professor associated with the KU in Leuven, here in Belgium. She is an expert and studies as well the intersection between EU data protection law and data law. So she's very well equipped to be here. And she brings her academic perspective. So if you have a question for academia, Laura is the person you have to address. Right next to her is Simon Hania. Simon has a lengthy career, but I will highlight his two last professions. He was a former DPO at TomTom. He was, until recently, the DPO of Uber, well-known automotive mobility company. And now he's on a sabbatical and thinking about his future. Sounds a bit vague, but maybe if he wants, he can elaborate on that. And Simon will bring his business perspective, perspective focused on fair competition. And right next to him, we have Georgia Bakatsia. Georgia, she is a legal officer at the European Data Protection Supervisor, EDPS. And during her work, she provides advice and guidance about EU data protection. Also broader, I have to say, right? Also Data Act and all the other data and cyber laws. And she does that in relation to the EU institutions, the EU bodies, the EU agencies. She will bring her perspective, logically, from that of a supervisory authority, a regulatory perspective. And last but not least, we have Berend van der Eyck. Berend is lawyer, works at a well-known international law firm called Bird & Bird. Berend advises clients, they have to deal with the Data Act, they have to comply with it. Is it correct, Berend, if I say that your clients are mostly manufacturers of connected products? Is that correct?
Some, but certainly not exclusively.
Not exclusively. So he will, that's his job to bring the Data Act to life in practice, and that's the perspective he brings with him. So those were the four panel members you have before you. Like I said, every member can start his or her lightning talk, and we start with Laura. Laura, please explain what your point is, and then you have exactly 7 minutes to substantiate.
Thank you so much. That's, of course, a very tight order. As an academic, I'm going to be rebellious from the start and in the beginning, a tiny bit explain more my perspective and then get to my main point. So I think, as you said, I'm at KU Leuven, and one of my tasks there is to teach a course that's called Data Protection and Data Law. And when I got this assignment, I was like, oh no, what is data law? And I spare you the details of the journey. I still have not found a full answer. But I think mostly if we speak about an area of law, we mean something with common principles, common concepts, a common narrative. And that's what I thought, okay, data law will have that. So now let me look at the different legislations most commonly associated with EU data law. That's also a rabbit hole, because where do you draw the line? But the Data Act, I think from the name alone, we can say that's clearly maybe data law. But I think in the data law, and that will then link to my main argument, you can see the struggle too. So I don't think there's an area of data law yet. I think we are talking about a bundle of legislations that have something to do with data, but the problem is that they have very different objectives. They go in very different directions. And I think even within the Data Act, which is supposed to be one legislation, we see the same. It tries to do a lot of different things that go into different directions. And that's why, and that's now my main point, I actually am not very convinced of the Data Act as one piece of legislation. I think it makes things extremely complex, and I will give some examples of this. I don't clearly understand the gains we will get from this, and I also am still missing, and that's maybe also my academic head, the normative framework. Like, why are we doing this? Who will benefit from this Data Act? And then there's 3 reasons that I want to elaborate on for my confusion and also my unconviction of the Data Act. The first one is, I think the Data Act has one of the most confusing scopes of applications that I have ever encountered. Basically, it has 7 to 8 chapters, depends how you count. And each of them has kind of their own scope and has their own version of data. So that is extremely complex, even for me, who's supposed to understand complex things, to just grapple what it is trying to do. The second reason is you have this interesting idea in the Data Act that it covers all data, but then also without prejudice to EU data protection law. So can we then really say it covers all data if there's personal data, we are no longer in scope, or at least not fully in scope. So I find that also very confusing. And then finally, and that's built on some work that I did with a colleague of mine, Charlotte de Kern, who is in general much more the expert on the Data Act than me, I see a risk that because there's this narrative, we have a data law, which presumes maybe common principles and so forth, the Data Act might redefine concepts that we already have. It might put a new spin on things in actually data protection law that I'm not sure that's what we want. And I will explain this further. To the first reason, all these data layers. So I really think that the Data Act has layers of data to uncover. To give an example, I think the first part of the Data Act, this is the part on the connected devices. Product data is defined, for example. So the first part actually only applies to product data, which is generously defined as anything generated by the connected product. Not clearly defined in my case. I find it difficult to see where the boundary of that concept is. Then we go to the next chapter, which is about, okay, how do you regulate these B2B interactions? And here it seems to be about data more general, so also personal data, but then think again of the without prejudice, so I'm not sure how this works. Then if you now jump a bit ahead, we have a chapter, I don't know how familiar you are with the Data Act, but there is a whole chapter on EU institutions can ask data from private companies. And here we talk about certain data. If you look at the scope of that provision, it's about certain data, including relevant metadata. And then if you read a bit further in the provision, it says there's special rules for non-personal data. I find it extremely confusing if you consider that personal data might not even be in the scope at all. And then finally, the last chapter is about, Joost already translated very nicely to you cloud services, but that's not the word you will find in the law because it talks about data processing services. And when I saw this for the first time, I went on a long witch hunt. What is that service? And it took me a while to understand it's indeed a cloud service. And that's only about customers' exportable data and digital assets. So that's actually broader than just data. It's also about assets, whatever it is. And I just don't know if this is in a time where we are pushing for simplification, and I'm also not fully in favor of that, if this is the right way to go, if we now suddenly have 7 extra definitions and concepts of data within one piece of legislation. So that's my first reason why I'm not super convinced of the Data Act's value. And I think if you now look at the omnibus, if that comes true, then the Data Act gets, because the idea of the omnibus that I think is a bit overlooked is also the Data Act will merge with the Data Governance Act and will merge with the Open Data Directive. And then you get even more concepts of data. You get open data, you get documents and data, because the Open Data Directive, despite its name, talks about documents. So another concept that we would have to deal with, you get research data and high-value data sets. And I really don't see how this is a very clear line going forward. The second reason for my confusion, I already kind of explained a bit, it's really this idea, okay, the Data Act applies to all data, including personal data, but then it's also without prejudice to EU data protection law. When I read this for the first time, I was really wondering, what does it mean without prejudice? So does it mean as soon as I have personal data, I do not apply the Data Act, but then why does the Data Act say it applies to all data? Because it only applies to non-personal data, actually. And also, who decides that it's without prejudice? Is this gonna be something that is decided by the user, the data holder in the moment, or is this gonna be an authority who eventually looks at it and say, okay, this was without prejudice and this wasn't? I find this a very unclear line, and I see an extreme risk for fragmentation, because of course, in the first place, it will be the data holder who decides this, when it's with prejudice and when it's without. And it will take years until there is going to be a decision by the Court of Justice. So I don't quite see how this will work. And then 1 minute for my last reason, which is this idea that I fear that the Data Act, and that's also linked to the story of data law, is really also shifting a bit the narrative, because the Commission likes to portray we have this digital rule book with the GDPR, the DSA, the DMA, and all these other acts, and they tell one story. But they really do not. Each of these acts has their own objectives and goes in a very different direction. And in my work, for example, we looked at the principle of fairness. Like, fairness is a big, big concept in the Data Act as well. And as you might know, it's also an important principle in the GDPR. I think hopefully for everyone in the audience, it's very clear these two don't mean the same thing, but that requires some knowledge, because if you just read fairness, you might think, oh, okay, it's about the same. But in the GDPR, fairness has this strong link with fundamental rights, with this idea of non-discrimination, power imbalances. While in the Data Act, it's about the fair market. It's much more competition-driven. It's about this idea we have one data market, and it should be fair and accessible for all, including for business. So I also think this idea of the Data Act and also of data law in general might risk undermining concepts that are built by fundamental rights in new data protection law in the long term.
Thank you, Laura. Nice bridge to Simon. Laura ended with fairness, fair markets. Simon, the floor is yours.
Thank you. My journey with what later became the Data Act started somewhere in 2016 when people were still thinking about and talking about the term big data. Yeah, I never heard that term anymore, but it was big data, which was a big thing in 2016, and so thought the Commission. So they were looking at a situation in which a lot of companies did not have access to data, let alone big data. And there was an incentive or an idea to democratize, incentivize, or at least create more agency for governments, for companies, but also for individuals to obtain access to that data. Mind you, we did not have GDPR at the time in force with the data portability provision, so that was seen as a good thing in this space. There was a study commissioned in which the commission was looking at a lot of companies that were data intensive. So Airbus was one of them, TomTom, my previous company, was part of it. And actually the commission was trying to establish how difficult it was to obtain access to data. Well, that varied depending on the company. And that resulted, after a while, in my view, in the Data Act, which is about redistributing data, or actually who gets to decide what is being done with the data. Now, if you look at it from a, let's say, consumer perspective, of course, if you buy a device, then the data that is collected inside the device, you bought the device, so the data should be yours. But it's locked up in the device, you can't get at it. And it was unclear whether the GDPR with data portability would provide you access to that raw data. So the thinking was, we need to unlock that data, we need to liberate the data, because if I have, as a farmer, bought a agricultural device, then this company, which may be an American company, can't lock up the data. And there was an interesting discussion where Airbus allowed the data owner was the airline, and Boeing said, no, we're the owner. So there was an interesting challenge there. The same with, well, I think you know the tractor manufacturing company that can hold its business users hostage almost. So the thinking was we need to liberate that. The same with what at the time was called software as a service. We now call that cloud service, in which you have put your data in your, call it Salesforce or whatever, and if you want to get out of a vendor lock-in, you need to be able to pull the data. So this is what the Data Act does. So it tries to stimulate competition, but it will fail. Here's why. If all users need to pull their data in order to share it with someone else, if I have my thermostat and I want to switch it, then I need to pull it and put it somewhere else or get someone else to accept it. That's a lot of effort for companies, so they will drag their feet. You can see that happening. So look at the devices you currently have and try to find out whether you can get hold of the data inside that device. So the Data Act has been enforced now. I challenge you to find companies that allow you to do so. I've done that with thermostats. Mine doesn't. I've done that with my e-bike. Yes, the company that builds the motor will allow me the data, but it is clearly designed by lawyers and not by product managers and user experience experts. It's undoable. So that's with respect to agency. Have you ever tried to pull the data from your car? The car you may not even own, but lease. Who gets the data? Or the car you've been driving in because it was a taxi or an Uber. Good luck with that. It's not going to work. That's one. On the side of the SaaS services, one thing the Data Act is completely missing is the notion of the fact that data does not only have to be pulled, but it also has to be ingested in a format that is understandable. We all know this from telecoms, number portability. We know this from email. You can move your email because the format is fully standardized. That's not something which is part of the data. So yes, you can get your data and then good luck with it. One of the elements also with all of this is that the data formats change with every software release, and software releases are churned out on a daily basis these days. So the dynamics are such that it's going to be very hard to do this. So that's why I'm saying well-intended, incomplete, incomprehensible, dead in the water.
You still have 2 minutes to add something.
To turn this around.
To turn it around.
I'll gladly give
Or do you want to?
No, go ahead. I'm done.
Thank you, Simon. So we started with an academic perspective, then to the business fair market, and now it's time for the perspective of Georgia, and she has a regulatory perspective.
Thank you very much. We have heard already a lot today about the Data Act for what it aims to be. A framework with a very ambitious objective to unlock the value of data, to empower users to access their data, to enable business to government sharing of data, and to foster innovation. Today, I will analyze the Data Act from a regulatory perspective, and I will focus on a different angle, its enforcement angle. And my main message is the following. The success of the Data Act depends as well on its effective enforcement and how this enforcement is going to look like after the Data Act is being reshaped by the Digital Omnibus proposal. The Digital Omnibus proposal aims for simplification and alignment. However, as I will analyze, it introduces certain blind spots to the oversight of data protection authorities. I will speak about 4 obstacles and how we can attempt to fix it, what the EDPS messages are on that. The first obstacle, it concerns the narrowing definition of personal data. As we know, the Digital Omnibus proposal attempts to narrow the definition of personal data. If this definition becomes the law, so if we go for a more relative, recipient-based approach, the jurisdiction of data protection authorities to monitor the Data Act will necessarily shrink. And why is that? Because the data protection authorities are competent to supervise the Data Act insofar as personal data is concerned. And I will give you an example. We have Article 17 in the Data Act that gives the possibility to public authorities and certain EU bodies, such as the European Commission and the European Central Bank, to request access to data in case of public emergency. Let's imagine the scenario where we have a public authority that requests data from a car manufacturer, GPS data, to manage a traffic emergency, for instance, an evacuation. Under the GDPR, this is currently personal data, and this is because a car manufacturer holds the key to link this data to the driver. What happens if the definition under the Digital Omnibus becomes the law? Someone might argue, the public authority in particular could argue that for them, this is not personal data because they don't have the key to identify the individual in question. So the jurisdiction of data protection authorities, also the jurisdiction of the EDPS, is going to shrink. And this is not a matter of institutional competence. It is a matter of fundamental rights that are going to be weakened. And this brings me to my second point. Even when it is clear that the personal data accessed is personal data, we cannot supervise what we are not aware of. Again, under Article 17 of the Data Act, public authorities and EU bodies, they have the possibility to request access to data in case of public emergency and notify the data protection authority if such access to data concerns personal data. This ensures transparency. It ensures that data protection authorities can monitor the application of the Data Act. However, this very same obligation is not mirrored at EU level. So when EU bodies, for instance, the European Central Bank or the European Commission, request access to data, they don't have the obligation to notify the EDPS. We cannot supervise what we are not even aware of. So we believe that this gap should be fixed with the Digital Omnibus proposal. And then we have the third point that I would like to address, that is a lack of sort of a legal bridge between regulators. So the Data Act introduces a very complex regulatory landscape. We have the competent authorities, we have the data coordinators, we have the data protection authorities insofar as personal data is concerned. However, what we don't have is a legal basis for these authorities to exchange information and evidence that they have, in particular, in context of their enforcement actions. This is something that currently is missing, and we risk creating regulatory silos. I will again give you a specific example. Imagine the situation where a competent authority is investigating a data holder for a Data Act violation, and they find evidence of non-compliance with the data protection law, for instance, a personal data breach. Here it is a gray zone. Sharing this data is processing. Can they share this data with the data protection authority? It is unclear. And my fourth point is a point that concerns clarity on the roles and competencies of competent authorities and data protection authorities in the context of the Data Act. And what I want to say with that, under the Data Act, there is an obligation for cooperation between competent authorities and data protection authorities. However, the roles are pretty unclear. Coordination is a very vague term when we don't define it specifically. So what the Data Act should do is to explicitly provide that for certain issues that they relate data protection concerns, there should be a referral mechanism. So the data coordinator should pause and should consult the data protection authority and ask a question. I will give an example here. We have a situation where a data holder alleges that the data set is non-personal data, but there is evidence that this might be personal data, and there is lack of clarity because, as Laura mentioned, the definition of personal data keeps changing. What do? Can they take a decision? Can they classify the data? So they should pause and consult the data protection authorities. And the 4 points that I mentioned today point to one single truth. Innovation thrives on legal certainty. We need to address these 4 gaps that I mentioned before, because this will make the Data Act stronger and not weaker. It will make it more safe for individuals, more workable for regulators, and ultimately predictable for businesses. Thank you very much.
Thank you, Georgia, for the compelling lightning talk. Berend, you are now responsible for all practical solutions possible after all these criticisms.
Making this happen. Well, I'll end with a positive note, but maybe I also have some critical notes to make here and there. We had the Data Act presented to us in February 2022, and it had the ambition, and still has the ambition, of unlocking and enlarging Europe's data economy, fairness in data sharing, enabling access to user-generated data, facilitating cloud switching. I'd want you as client refer to the Data Act as a damn EU socialist law. But whatever you think of the Data Act, I think it's bold, it's novel, and it's very ambitious. And it actually, as a lawyer, gets me excited. It reminds me of the first days as a lawyer when we were figuring out whether a hyperlink was a communication to the public. So that's a little while ago. But these wild ambitions only work with excellent execution, and I think that's where the Data Act falls short. I have to be candid. The Data Act is riddled with ambiguities, undefined concepts, internal tensions that the legislator has effectively delegated to the markets to resolve. And yes, I think the Commission deserves compliments for their efforts to engage with the various stakeholders, through webinars, a help desk, FAQ and the like, but I cannot help but think that these efforts are an equal part of genuine support and execution of legal obligations, but also a form of remedy or an apology to the market for dumping this on us prematurely. And I really wish it was different, but the Data Act is currently far from operational in practice, I say. And that can also be in part explained by the fact that we only have 4 member states that have implemented the Data Act, but I don't think that's the whole story. The Data Act is a regulation. Many of the rights and obligations you can simply go to court for. And this week I've asked my colleagues, does anyone know of any court rulings so far on the Data Act? And unfortunately, the answer is no. And Joost, you are Mr. Legislation and court rulings. You
Couldn't find, no.
nothing. So if anyone in the room has any court ruling, no, I see some hands shaking.
No.
in disappointment. But that's where we are. And of course, it's a little bit early to draw conclusions from that. We're 6 months in, or 8 months, I think. But still, also from advising clients and hearing this in practice, there's little awareness, and certainly overseas, apart from the right in Chapter 6 to terminate cloud agreements, because of course that impacts revenue potentially. And the companies that do try to leverage the Data Act for their benefit are often running into all kinds of obstructions brought up by the data holders or data processing service providers. They're cleverly hiding behind the law's ambiguities, complexities, interplays with other laws, and lack of enforcement. And my main point, as requested, is the gap between the Data Act's aspirations and its legal operability. And that gap is significant. And unless this is addressed through robust guidance and effective and well-considered enforcement, I think there's a risk that the Data Act will in fact undermine the very innovation in Europe that it seeks to promote. But we are not in uncharted territory. There is a thing called PSD2, which encourages or actually prescribes open banking rules. And that provides a very useful precedent to see how mandatory data sharing regimes work in practice. The Commission's own review in 2023 describes PSD2 as a mixed success. Yes, it created enforceable access rights, but several structural problems emerged that are directly relevant for the Data Act. A colleague of mine said PSD2 succeeded legally, but fell short commercially. And that's certainly also what I see in practice. And that's due to a number of things. I'll highlight a few of those. Standardization proves critical, and in case of PSD2, insufficient. Banks, ASPSPs, for those who know, show reluctance to share data, and there was a lot of API fragmentation, forcing third-party providers who could leverage these rules to maintain countless of integrations. And I think this will also be crucial under the Data Act. Will users and third-party really get usable data and usable access? Will third parties be able to combine that data from different data sources and build products and business models around that? I doubt it, personally. Second, incentive alignment matters. Under PSD2, banks were faced with significant API costs and were prohibited from charging for access. The Data Act does address this through the reasonable compensation standards, but I think that will lead to much discussion still. Of course, there is guidance upcoming, but this is quite a crucial point, I think, for this part of the Data Act. And third, trust, frameworks, and viable business models take years to develop and not months. And the most telling signal is that the EU has already moved to PSD3 and PSR, which is acknowledging that PSD2 was successful enough to keep around and expand, but not successful enough to leave unchanged, and much will change. And I think the lesson for the Data Act there is clear. Legislation alone does not create a functional data sharing ecosystem. It requires infrastructure, standards, market confidence, and what was also mentioned, clear rules. So where does this leave us? I would characterize the current state of play as a bumpy ride, and one that remain bumpy for the foreseeable future. Member states need to expedite implementing the Data Act, and the European Commission will need to continue giving adequate attention to the Data Act by implementing acts and guidance to properly kickstart this endeavor. More than other laws, I think regulators will need to be vocal and hands-on to generate and keep momentum for the Data Act. My compliments go to ACM and also to the AP for doing their part in the Netherlands and frequently organizing and participating in events on the Data Act and publishing quite extensive guidance. And I fully appreciate the Data Act is complex and ambiguous, and it has to compete with AI and with cybersecurity, and it doesn't go down as easy, and certainly not in boardrooms. But if we all believe that this is indeed beneficial for the EU and its businesses and citizens, then we need to double down and we need to make this work.
Thank you, Miriam, for this, I think, great, also rather optimistic, right? Yeah. For a lawyer, that's quite something. No, that's my take. Now we have more than a half an hour for you, the audience, to ask questions. If you are willing and able, please stand up. We have a microphone for you. State your name and if you want the organization you represent, and formulate a question. Formulate it as a question, not always the case. And please tell the panel member you want to address. Who will take this opportunity? Oh, I see, Gloria.
Hello, Gloria González Fuster from VUB in Brussels. I have a question or just to double check, maybe for Simon or maybe for Laura, I don't know. I heard a lot of pessimism, and 2 weeks ago I was also thinking this is never going to work. I don't know how to get data from anything, but I'm happy to report that 2 weeks ago I did get the data from my fridge. And not only I got, yes, but not on my own, so we were with a group of students and some smart people. We found that the right page of the right company was actually you could get the data, and during the night they sent the data, I woke up, I had the data, I downloaded this data, and indeed I couldn't understand everything just by reading it once, but I'm not that stupid that then I could just check some things and I could understand, this is what is happening with the fridge, the door is closed, open, a lot of things that we could understand actually. And then we realized also the Data Act is saying the data doesn't have to be meaningfully, immediately intelligible, but you will understand it somehow. So just to tell you, I was happy. I was like, yes, maybe it works, it can work. I can actually use this data. A computer scientist can use this data. So my question is, I don't know, am I just now crazy? Or can we still believe a little bit that some users are possible and somehow it will work? Thank you.
Let me
Simon.
get to that, because I mentioned I have an e-bike. I was also able to do that. But I think this is a research and hobby. This will not result in relevant and massive sets of data that will be used by others. I really don't think so in that way. I think that if it takes multiple people to tango in this case, not just the manufacturer of this specific fridge and yourselves, but also others who actually build a service that is useful to you, and then they reach out essentially to these manufacturers to set up a deal. Where are the money flows? If this is going to be a hobby project, it's not going to work. I've seen this happen when at TomTom we were building sports watches for the first time. We had the first one who had heart rate monitoring, and we opened up the gates to others. People weren't interested aside from a first blip. Now, my point is that we currently oblige each and every manufacturer of connected products to build the investment, to build these tools. That's not cheap. To build these tools, to actually be able to have someone download it. That's a real issue. So what we're doing is we're actually increasing market entry barriers for Europe, which do not exist outside of Europe. That's what we're doing with this specific, the specifics of having to pull the data. And given the amount of benefit, I seriously doubt whether it will actually, rather than stimulate innovation, actually keep some innovation out of Europe. In particular, if it's enforced, and in particular, if it's not enforced. Did you know, one of the largest IoT platforms in the world, if you have a light bulb on Wi-Fi, which is not a Philips light bulb, then it's highly likely that it will run on a Chinese platform called Tuya. Try to get that data. Good luck with that. Who's going to enforce? If you have the data, why would I be interested in what you were saying? The door opened, the door closed. That's fine. I can get that from their app. And they could provide me also with all kinds of stuff, which they do. So I doubt the business feasibility, the business relevance, and hence the effect on competition. It is nice for a hobby, period. That's my take on the IoT part of the data. Yeah.
I see here people. No, I see a lot of hands in the
You
air.
triggered something.
But Laura wants to. Laura wants to react.
On purpose. So
Laura, Laura, can you give a brief
very short.
response?
Yeah, I
and
think
then we go to the floor.
that indeed the access rights that the Data Act gives and also the portability idea, those are great ideas, but they're just drowning in a lot of vague concepts. And if that was the point of the Data Act, then we could have just called it that or made it clear that the purpose is transparency for users, understanding of what happens with the data and the ability to reuse the data. But that's not anywhere clearly stated, or at least I haven't found it in my many searches of the Data Act's purpose.
Okay, thank you. I see Pia, you there, Caroline. Yeah, okay. Please go ahead. Yeah.
Hi.
You can go, and Pia after you.
Perfect.
Yeah.
Hi, Pia. I'm Caroline. My name is Caroline van Ekeren. I work at ICT-recht. And I have two questions. Actually, one for you was Berend, right?
Yep.
So I have been I've been reading Data Act and hypothetically thinking about all the situations that might arise, which are not arising, also my experience. But I was curious if you had experience with a legal person as a user requesting data.
Yes.
And the assessment that you would then do, also based on GDPR and the personal data involved. And if you could share a little bit about that. Do you want me to ask my second question now as well? Because it's actually quite short.
Sure.
Which probably will be for you. If I look into the consideranten or the recitals of the Data Act as well, I also read the Without Prejudice 2, and I wonder how you see the relationship between Data Act and GDPR, and whether or not the GDPR, if they are in conflict, would prevail over the Data Act or not. That would be the second one. Okay, cool.
Okay.
Thank you.
Noted. The first thing that comes to mind when you mentioned a legal person requesting access to data is not something that you're looking for, but I'll say it anyway. It's about a company requesting data from another company. This is a company that uses all kinds of machinery in their factory, and I got them so excited. The legal counsel specifically that he or she gave a presentation to the colleagues and said, "Guys, the Data Act is here. Let's leverage it. We can get all kinds of useful data." And so they went on to their biggest supplier of machinery, and that was 6 months ago, and they still don't have the data. And there's a lot of forth and back. There are, instead of Excel files, unreadable PDF files being shared. There's a lot of obstruction, long emails that get more legal, and also the people from the business, her or his colleagues, are getting anxious because this is starting to upset the relationship with their largest supplier. What do you do? Thankfully they said we're going to put our foot down, because this is not only for now, this is also for the future. We want to make sure that we have a level playing field. If others are getting access to the data, we want the same, and if they haven't thought about it, then it's on them. But still, you're taking quite a bit of a gamble, and it's a very big project. So that's one, and maybe the other one was you were thinking of the GDPR and the interplay there, or not?
Yeah. This is something that I wonder, mostly like if you get, for example, a company would. Sorry, I'm also a relatively loudspeaker, but for the online people. Yes, so if it would be location data or anything that is sensitive, for example, from an employer who's saying, okay, or in a supermarket, sometimes they use AI within those cameras to check whether or not people are stealing stuff, right? And that supermarket will be like, okay, we want to have all the data on everything that you are using. And that would obviously be quite a lot of sensitive data as well. So there would be an assessment having to be made from the supplier who would say, okay, what data can we share and what data can we not share? And I was wondering if you have experience with that, because that would be really fun, I think, to do.
That would indeed be fun. I would actually think in practice again that these things are probably done through a controller-processor relationship if it concerns personal data. But hypothetical, I haven't seen it yet through the Data Act. If a data holder gets a request from a corporate data user concerning data that is not related to the user, then the data holder needs to make an assessment. Or actually, yes, the data holder needs to make an assessment, but effectively they would say, well, show us your assessment. Otherwise you wouldn't get the data. Yeah. And what My observation / frustration is that every time a data holder doesn't provide the data under any of the other exceptions, it has to inform the regulator. The moment you invoke the GDPR, you don't have to inform the privacy regulator. Let's be fair and also do that. And then that GDPR is broad enough. It's going to be a very difficult discussion. It's a very powerful weapon, but I think the data holder has to ask the data user, also based on the standard contract that we've seen, to no.
Let's move on. Pia, I saw you have the floor.
Yes, so my name's Pia Grunewald. I'm a doctoral researcher at the VUB, part of LSTS with Gloria. And my question is actually for you, Simon, and well, just a bit of a reflection, because you brought up this very relevant point. Okay, you can access your data. Not every company has the capacity to do that. As you mentioned, Berend, that sometimes you get this access request and it's quite complicated for the company to decide how do we create these boundaries around this data to make it accessible for someone, but also not give everyone our data. And I think this is a trouble with how we deal with our imaginaries of the data economy. So holders of data from smart connected devices, also from other types of shops or anything, they want to keep their data. They don't necessarily make it standardized. Even if two companies merge and they want to start standardizing it, it's not even possible. Like, it doesn't communicate very well with each other. And then when you want to access the data, you can access it on a personal basis, sort of like for yourself, but it's not really relevant. You can see what they're doing, but there's no way to monetize it. Now, I'm seeing some companies emerge in Europe that operate as data intermediaries, where they are, on the one hand, you have data intermediaries that have a very paternalistic view. Oh, darling data subject, you don't know how to handle your data. This doesn't make sense to you. But if you send this request for us, we will put your data in a big vault and we'll be able to run our big data thing, going back to 2016 for you, our big data analysis, because you're giving us access. And of course you can get it back, but it still kind of replicates this holding of data, just it manages to purchase it via access requests from data subjects, sometimes through nefarious means. On the other hand, you have some data intermediaries that are deciding to operate more as a commons. And so from that, they work on getting access requests from data subjects, because this tends to be the more accessible way to do it. And then they put it into a repository where any data subject can access it and also use it to create their own businesses. And of course, you have the question on monetization. It's not a big model, but it does create the system, at least in Europe, where based on this access request, based on GDPR and the Data Act, you can create new business models for others where newcomers to the market can access the same data that old entities have been holding for the long time. And so this is a little bit of the reflection I'm seeing. I've spoken to some DPOs who've had access requests, and if you're a DPO here and you want to talk to me about access requests and honestly how it's done, I'm very curious. But what can you say about like this intermediaries in this business model? Is it simply, yes, on a personal level, maybe it's not relevant, but when you start to collectivize it, do you see this paternalistic thing emerging, or is there a possibility for really having a commons thing? And of course, I'm not trying to say a commons is ideal. There's also the tragedy of the commons. A lot of businesses that collectivize this data, make it accessible, also have the trouble that people like, download, thanks, bye-bye.
Simon.
So I think the idea in a qualitative way can make sense, but I think that the business economics of it do not add up. That's the issue I see. I think there's not too many people that will go through the trouble, are digitally sufficiently savvy to actually pull the data and have it contribute to this data intermediary. And I think the data intermediary, I don't see a viable business case for data intermediaries based on this voluntary, still labor-intensive contribution by individuals. Because Otherwise, we would have already seen it based on GDPR data portability, which has a similar effect. Now, it's not entirely, because I know that data portability is about the data you contributed, but you could argue you contributed it. No one has gone to court over it. So I question the business viability of this entire idea, while at the same time, there is quite a cost to force everyone who builds for Europe to implement this functionality in their back-end systems, which is expensive and costly. So that's that, and cumbersome to maintain. So that's why I'm saying, from a qualitative perspective, from an idealistic perspective, it's wonderful. In practice, it will not fly, I think. The areas where it will fly is when there is a clear business imperative or option, and that's, for instance, in cars. If you want to have a third-party maintenance company, they need access to the data. Actually, that's been regulated by the EU through a physical connector in your car, the OBD2 connector. It's in each and every car. It's mandatory, and the data formats are open source, and the semantics of the data you need to buy from the manufacturer, and they have an obligation to deliver it. And that's why QuickFit and the likes can operate. Which goes back to what Berend says. If you want to do this, you need to do a sectoral approach together with interoperability requirements and requirements on semantics, and then think about the way you construct a business model around it, and maybe forcing companies to do this for free to qualified recipients, or have that as a marketplace as well. And that's where the intermediaries could play a role. But the Data Act as a horizontal instrument is too wide, too blunt, and it lacks the incentives to do so. That's the whole point I'm making, and that's why I think the Data Act from a competition perspective is not a good idea, because it creates cost and the benefits are entirely uncertain. Then I think it would be way better to have specific regulation on those devices that really require it, like cars, and that's where it's happening.
Thank you. Who has a question for Georgia about enforcement? Or yeah.
Thank you. And my name is Akihiro Koide. I am from Leiden University. I have a question for Georgia, and I also for Berend. And I understand that there may be cases where it is difficult to determine whether certain information constitutes personal data, and before that act, assuming that such information is personal data and complying with the GDPR was usually the safer option in many cases. But however, under that act, if certain data is personal data, it can be the basis for an argument that our data holder will not provide such data to its business users. And I'm interested in how lenient are regulatory authorities towards such an approach to assume that certain data is personal data, even if it's not clear, and to refuse give it to business users. And I also would like to know from the perspective of lawyers and how you would advise typically in such cases, although it may, of course, it depends on particular facts.
Thank you.
So the question, if I may rephrase to be sure that I understood well, is what happens when it is unclear whether data requested is personal data or not?
Yeah, yes.
Mm-hmm. So this is the very same problem that I spoke about before. Currently, there is lack of legal certainty on how to handle these situations. What should happen normally, and this should be clearly and explicitly framed in the Data Act, is that there is not just an obligation for regulators to cooperate, but there should be a formal referral mechanism from the competent authority to the data protection authority that should have the final say on whether data is personal or not, because it may be the case that data holders will try to frame their request in a way that they would argue that this is non-personal data, why it may reveal very sensitive patterns about individuals. So this is a very real risk, what you are you spotted.
And I also interested, there may be also a problem because companies have to decide on that before intervention of regulatory authorities.
I'm not sure I understood
that companies usually they should foresee the outcome, how authorities will decide whether certain data is personal data or not. But even if regulatory authorities will resolve that data, finally, it's still unclear what should occur if regulatory authorities did not resolve it, but companies decided to. Companies still need to decide which is the safer position.
Yes, that is a real issue, that it is difficult for data holders, also for the regulator to classify sometimes whether data is personal or not, and this becomes even more complicated under the digital omnibus proposal if this definition becomes the law. So you raise a very valid point. It is not easy to identify that, and also identification is not a static concept. It may be the case that today it's impossible to identify an individual, and in 2 months, with the technology evolving, it may be the case. So that's why there is legal uncertainty currently in the law, which creates a lot of problems.
Okay, thank you.
Thank you.
Yeah, maybe to add from a practical perspective, how I would go about it, advising clients, depends on the site. If I'm working with the data holder, then of course we will look at the GDPR and see if they are reluctant to share data, if we can invoke the GDPR to not share the data. I think just personally looking at this, it should be fair to also inform the Data Protection Authority if you invoke the GDPR and say, well, we cannot share the data under the GDPR, due to the GDPR. There's also a consideration in the Data Act which says if it concerns personal data, you don't have a lawful basis, then you can share anonymized data. So what data holders can also do is they'll say, well, sorry, we cannot share personal data, you don't have a lawful basis, we're not convinced, but here is a lot of aggregated data that you cannot use, good luck. So there's I think data holders in that sense have quite a strong ally in the GDPR, despite the many obligations that they do have to meet.
I saw people raising hands in the corner. Yeah, over there. Do you see them? There, with the person with the glasses. Over there. No. Further. No, yeah, you also have glasses. Yeah, but the person over there was before you. I'm sorry.
Hi, thank you very much. My name is Yuri, and I'm with the Dutch EPA. So recently, I did a data act request for a connected vehicle. It's a 2025 model, so I thought this is worth reducing. And what I received was quite a letdown because next to the fact that it wasn't legible, it also just wasn't much. And I couldn't really believe that this was everything that came out of the car. So the first question would be, how do you know as an end user that the data that you have received is really everything that's available in that car? And so that's question one.
So the question is, who do you address for this question?
This is an enforcement question.
Georgia? Yeah, okay.
So the second one is, let's say that I have the data now, it's a bit more, and I want to make sense of it. I'm not much of a hobbyist, so I want to send it to a third party. Then I believe that this third party has to pay the car manufacturer just to ingest this data. And I saw in some car manufacturers that this goes up to like 30 euros per month. And then I wonder, like, who is going to provide me a service if they have to pay the car manufacturer 30 euros per month to start? That's really one.
Yeah. Georgia, can you help your colleague?
Yes, absolutely. Thank you very much for the question. That is a real issue, what you are raising. What is positive here is that the data protection authorities, they have powers under the GDPR that when it comes to personal data, they can exercise. So if you have doubts on whether this is all data that comes out of a car and it looks weird to you, you have the possibility to check. You have the possibility to audit. So all competencies and powers under the GDPR are fully applicable here. For personal data, yes. So from the DPA perspective, absolutely.
I think this specific car manufacturer may have actually apply the data minimization principle to the max.
Thinking the same.
What I mean is the data may very well be in the car, but it will only come out of the car when requested. And there is some data that's coming out of the car on a regular basis, and that's what you probably receive. So I'm not entirely sure how the Data Act is phrased, but there could be data in the vehicle, just there. The ECUs, as they're called, there are tens of them in there which have the data, but they will only pull it upon request. And what you've asked for, or what you've got, is the data that is pushed out of the car on a continuous basis. So it's very well, you don't know, but this is my hypothesis here. Yeah. Also, sending all of this data off board costs money too. So that's why your 30 euros is there. Part of it just goes to the telecommunications companies to actually make it happen that the data is pulled out of the car. There's a lot of cost involved in maintaining all of this. And be aware that cars require type approval, which isn't free either. So there's a lot of cost involved, and it goes to my point that the business viability of this is very questionable. Now, I've been involved in the past with a lot of these conversations with car manufacturers for what's called telematics services. So vehicle tracking, tracing of professional cars. And actually 30 euros is a pretty good deal, actually. If you think of the cost involved in maintaining it with software updates and so on, it is not cheap. It will add to the cost. Also be aware that it may very well be that on other devices, the reason why the consumer electronics is cheaper than a car is because a car needs to be there for 15 years at least and support consumer electronics much shorter. And it'll die because the cloud services are gone. It may actually be subsidized partially by the data that's being pulled that is subsequently to use to feed some AI model. Very well possible. That's my Chinese car light bulb comparison. So there's a lot of business models that all of a sudden the Data Act is interfering with in unknown, unpredictable ways. And your point on asking the data now, what do you do as a regulator if you have a suspicion I don't get anything? Yeah, do I have the competence to go out to that car manufacturer or start asking? Or do I need to first talk to the type approval body because it might be someone in type approval regulation? I don't know. I sincerely don't know. So I'm hypothesizing a bit here and giving some background explanation. But yeah.
Laura, sorry for putting you on the spot. I haven't heard you for a while. Do you want to respond to this or no?
I'm good.
You're good?
Gloria,
then I saw a lady all the way in the corner. You were raising your hand for so long, so please go ahead.
No, thank you. Amanda Terhonen, I'm from Finland, Helsinki, from a law firm, also NOIP alumni. I was, actually, my question was a bit discussed already, but I want to take the discussion a bit further. It's related to the lack of legal basis when data is shared to corporate users. As the data,
is that a question for Laura, for example, or anyone?
Anyone who feels inspired to respond. Yes.
Chance. No, okay.
And so I see there an issue that the Data Act does not create a legal basis for the data sharing, and I believe that the intention of the regulators was not to exclude personal data of this data sharing regime. I don't know how your views are. It'd be interesting to hear if you see a practical issue here or not. And as I believe, like Berend said, this might be a powerful weapon for controllers. Or mostly, I also advise they say that this data includes personal data. We cannot share it. But do you see that there are situations that a legal basis could be available, especially for the data holder, and could the user somehow argue that there is a legal basis to share this personal data, and after this consequently receive the data they request? Thank you.
I'll try my best. I think you raise an important point indeed, and that was also one of the points of confusion that I brought up. I find the relationship between data protection law and the Data Act very unclear. There's this without prejudice provision, it's in the recital, but it's also really in the text. And indeed, if you leave out the Data Act in the GDPR, if it's personal data, you need a legal basis. There's no, like, you cannot use the Data Act as a legal basis itself, so you need something else.
Why not? Yeah, I also do. Sorry.
I don't think it was meant as a legal basis, no?
It's not meant as a legal basis.
It's still a law. So
Yeah.
here you go.
That's only for specific situations. But I agree what you're saying, because everybody is extrapolating that to all situations. But I think it's only for the situation where the user is requesting data that is not related to the user. And if the user is the data subject, then I would argue, but I'm a minority, that you have a lawful basis as a legal and the
but
legal
then you have just
obligations.
your right of access, no? For your own personal data, you don't need
No, but the data holder would have a lawful
a
basis.
legal basis to
under
but
the
we,
data
I mean,
Act.
under the GDPR, we do not ask if a controller has a legal basis to share their personal data.
Yeah,
if there is a right of access.
that's also true. It's
Yeah.
it's a little bit moot, but it does see the other way around. I think it's valid. You need a separate lawful basis for the scenario where the user is not the data subject.
I also would say
So the question is, do we need a new legal basis for data sharing? Right? Yeah.
Yeah, I would say so, but I really am open for all opinions because the Data Act puzzles me. But I would say, indeed, I think it's a new purpose, it's a new thing you do, so you need a new legal basis. And if you say, okay, the Data Act is the legal basis, so it would be a legal obligation, would that be your argument?
Yeah.
But then we would have to check very carefully, what does this legal obligation cover? And I'm not sure it fully matches all the situations where a user asks data. And another point that I think is important, that I feel the data kind of assumes the data holder is the controller, but I don't think that will always be the case. The data holder might as well also be a data subject or like something else. So, and also, who is the controller? Difficult question in itself, a Pandora's box that's under GDPR not really resolved either. So yeah, you have a good question. I don't have an answer.
Sorry. You saw someone in the crowd. Hopefully, Gloria. Yeah. Gloria.
I wanted to briefly come back to the previous question, because I think the answer was a bit speculative. So I think there is no difference as such between the data that is in the car that is being sent out continuously, because the Data Act also covers the data that is in the car, but when it's only pulled out when you go for maintenance, for instance. So that is not really relevant. And I would say that one of the obligations of the Data Act are these transparency obligations. And normally, if your question is which data is in the car or is being produced by the car, the first way to answer that question would be read the transparency thing that they should have, not just do the access, that would be another stage, but first they have to give you a list of this is the type of data that this is generating, that we believe is under the Data Act. So there are some transparency requirements that I think can be useful for you.
Yeah. Wesley? Yeah, here. The other guy with the glasses.
I'm a careful optimist, I would say. Yeah. Sorry, Wesley Horion. I'm from Pins and Masons. I'm a careful optimist. I do think that there is still some life in the Data Act, namely for the insurance industry. I think there is quite a lot of potential, but careful optimist, because I think that the pitfall is trade secrets, something that has not been reported yet. And this is for you, Simon. What do you think?
Are you talking specifically about car insurance or about fridge insurance?
Insurance. It can be car, it can be personal, medical, whatever.
Now, I don't know the current state of affairs, but I've been very much involved in vehicle insurance, in particular for younger drivers who have a different risk profile. And yes, there are offers out there to do this, but they make sense in those countries. They make sense in those countries where the driver is insured and not the vehicle. So there are countries in which you have car insurance, and there are irrespective of the driver, and then it gets diluted anyway. And there are countries where you have individuals insured. So in the UK, that was the case. In the end, you also have to realize that insurance is also a collective product in which we rely on. So if you as an insurer are starting to differentiate too much, so there's a lot of other considerations there. What I've seen in the past is that it was seen as a holy grail somewhere in 2018. Various business models were introduced in Germany, in the UK, in the Netherlands as well. But in the end, and they were actually using these dongles that you put into your OBD2 connector, but the data is not necessarily shared with the insurer. It's much more shared with you to provide you feedback on your driving behavior, which you then improve. And that's not necessarily something that needs to be shared with other providers. It could be just the insurer that indeed pulls the data. But I was optimistic at the time because we tried to build a business model. And also that didn't really work. Insurance on behavior in houses. So are you at home and so on. So there's a lot of data you're actually putting into someone's basket. I still don't know whether it'll work. And in particular, because there's a tension with the collective nature of insurance. So,
thank you, Simon. We are entering the final phase of this beautiful panel. 3 minutes left. Let's use that time so our panel members can react on the following question. The Data Act, is there future for this wonderful law, or is it dead on arrival? Let me start with Berend. You have 30 seconds to react.
Well, it's certainly not very alive. I think that's as much as I can say on that part. And I think if we all believe in the Data Act, and I think that's a mixed opinion at the moment. But if we do believe it, we have to double down on it. We have to make the Data Act come alive. And that's on us, on businesses. And if it's not working, then please let's pull the plug or maybe another omnibus. But I think we at the very least need to give this proper attention or bury it.
Thank you. Georgia.
So I would say from this discussion today, my take is that there is a lot of legal uncertainty. We are not able to respond to even questions that they should be basic, such as the legal basis, etc. So for the Data Act to have a future, I think the Digital Omnibus proposal gives an opportunity to reshape the framework and fix the gaps that we have collectively identified here today, and there are many more as well.
Thank you. Simon,
I already said it. I think it's dead on arrival, and that's because it's too generic and too horizontal. I really think that if you really want to foster the data economy, you need to be sector or application specific and also mandate interoperability requirements. Otherwise, I don't think it's going to fly, and it only adds cost, which we have to pay. By the way, also lawyers' cost. It's a lawyer's paradise, as we heard.
Okay. Laura.
Yeah, I think the Data Act is clearly not that, because there's people here interested in it. So I taking a pragmatic view, I hope it can give us something. I just think, and it was mentioned before, we need to maybe now indeed use this digital omnibus to make it more coherent, to give it a clear objective, to also decide what we want to do with it, because right now we want to do 7 different things that do not always match. So can we maybe focus, it's like a master thesis that I sometimes get, like the scope is all over the place. Can we not focus on something clear and then get that story straight? And I see a point in the sectoral data economy type of thinking that was brought up by my colleague.
Thank you. Thank you all for listening. Thank you for your questions. You have been a terrific audience.